135 participants. 37 participants. Oh, দেখি mail করে দিচ্ছি।
Good morning, sir. May we start?
Yeah, please start the program.
Okay, thank you, sir. Good morning, Vikram, sir, and good morning to one and all present here. Welcome to the 4th episode of Colawquia organized by XSLAJ. The topic for today's discussion is Rights Delivered, Rights of the Victims under the Indian Justice Delivery System. My name is Ronald, and I am the MC for the event. I would like to begin by speaking a few words about XSLAJ and what is its work. XSLAJ stands for Xavier Society of Law and Justice. It has been established under St. Xavier's University, Kolkata, to achieve quality-based legal education, and it aims at preparing men and women so that they can help others. In its constant pursuit of excellence, it always strives to create a legacy of leadership, professional acumen, and excellence. This society strives towards exploring the benchmarks of educational standards for the best outcome in the areas of law. Colloquia is the talk series organized by XSLAJ on a monthly basis, where dignitaries from the field of law are invited so that they can share their experience and knowledge with us, so that all of us can have an enriching seminar, which is currently being held online to suit the need of the hour. But on the other hand, this webinar does not only suit the interest of the law department, but also of all the departments and all the students, because this webinar aims at sensitizing the role of law and justice in today's day. With this, I would now like to move on to the introduction of the guest speaker for the day. Today, as guest speaker, we have Mr. Vikramjit Sen, who is presently posted as Additional Chief Judicial Magistrate at First Court, Paschim Medinipur. He is part of the 2011 West Bengal Judicial Service and has completed his postgraduate diploma in management from IISWBM and has completed his LLM from Calcutta University. Sir, it's an honor to have you today here with us, and I'm sure that all of us will have a great time of learning and knowledge with you over here. And before I hand over the proceedings to sir, I would like to mention a few things which are needed to be kept in mind. This webinar will be from 11 a.m. to 12 a.m. and the questions will be attended to at the end of the session. Attendees who have questions may contact a student reps for listing their questions. Their contacts will be provided in the chat box shortly. Thank you. Now I hand over the virtual mic to you, sir.
Thank you, Ronald. And I would like to take a moment for thanking the Xavier Society of Law and Justice for organizing this virtual workshop. And my sincere thanks to the faculty members of St. Xavier's University Department of Law for having me in this workshop. Now, I have already mailed the presentation to one of the organizing members. So I will request him to share his screen and the PPT that I have mailed to him, Harsh. So it would be helpful for me to present the topic.
Yes, sir.
Nice to see you, Animesh, after so many years. Huh?
Nice
I
to
hope
see you, Vikramda. How are you?
fine, fine, quite fine. Yes.
Sir, we'll share in a moment, sir.
Okay, I believe we are having first, second, and third year students, and I'm not sure about the course structure, but I believe most of you are having some idea about the Indian Penal Code and CRPC by this time. So I'll be taking you through the provisions of law in the penal code and the procedural code, which are beneficial to the victim, which are designed to protect the interest of the victim during the criminal trial. Yes, can we have the slideshow?
Is the slide so visible, sir?
Yes, the slides are visible. We can go to the slideshow mode. Yes. Now I have selected this topic, the rights of the victim under the Indian criminal justice delivery system, uh, which may appears to be a relatively very boring topic, but as a student of law and would-be practitioner of law, it is our obligation to ensure that we live in a equitable society where the victims' rights are protected, and not only the victims, anybody who is a citizen of this country, they are having certain rights under the law, and it is our duty as a student of law or a practicing advocate to ensure that the rights available to them are applied and they can enjoy the benefits of the provisions of legal protection. Now, if we go through the various provisions of law, we'll find that the term victim is defined. Can we go to the next slide? In the criminal procedure code and certain other. Sorry, can we go to this next slide? In the criminal procedure code and certain other enactments also.
So it is in the next slide.
I think there is a lag in connectivity. In any case, the victim page is showing. I am seeing the first slide.
Sir, is it now showing?
Yes, it is now showing. So who is a victim? So if we take a general idea about the term victim, we tend to assume that a victim must be a person who has suffered some kind of injury or harm at the hands of some other person or group of persons. But if we go through the provisions of the Indian Penal Code, we'll find that the Indian Penal Code has divided the chapters in certain sections, and there are various kind of penalties imposed for various kind of crimes. So there are certain penalties which are imposed for committing crime against the society. There are certain other kind of penalties imposed in the Indian Penal Code for committing offenses which are directed towards the nation. We can say that even the property of a certain person or the property of a nation can also be a victim, because if you destroy, suppose, a public property, there are laws which prevent destruction of public properties. We have special laws also, Prevention of Destruction of Public Properties Act here in Bengal. And in the Indian Penal Code also, we can see that there are certain sections which protect the property of an individual or the property of the country. So even a property which is not a living thing can be a victim of a crime. Now, interestingly, I have put one more point, that is accused. If we go through the various provisions of the law in the Indian Penal Code as well as the Criminal Procedure Code, we'll find that the law recognizes the right of the accused also. And the right of the accused are enacted in the form of protection to him for having free legal aid if he's not in a position to hire his own advocate. His right is also protected against self-incrimination. So you cannot force an accused to give evidence against him. The accused is also given compensation for wrongful prosecution. So even an accused may be a victim in certain cases. Suppose someone files a false case against someone and a person is wrongfully prosecuted, then he is also a victim of the criminal justice system, delivery system, because he has to go through the entire trial stigma of being called a victim, an accused. The standing of that person in the society also suffers because he is a criminal. He is in the eye of the society, he is a criminal. So if someone is wrongly prosecuted, that person, although he is accused in the narrow sense of the term, but actually he is a victim of the system. So at the end of the trial, if he is acquitted, he can press for compensation for being wrongly prosecuted. So I have included the term accused also in the definition of victim. But today we will confine our discussion to the victim, which has been defined in section 2WA of CRPC. So victim is someone who has suffered injury or harm, and he is or she is a victim of the crime or the offense, and for that reason the law recognizes certain protection for her or his benefit. So if we go through the definition of section WA of CRPC, we'll also find that the term victim also includes his or her guardian or legal heir. Now we'll go in details to this definition of victim and the law explained by the various judgments of the Honorable Supreme Court as well as the High Court. But today, since I have selected a topic that is for discussion today is the right of the victims under the Indian criminal justice delivery system, we will mostly be confining our discussion to the victim which has been defined. Now, if we can go to the next slide, we'll see that Honorable Supreme Court of India in Maru Ram versus Union of India, the citation you can see in the screen, had observed that a victim of crime cannot be a forgotten man in the criminal justice system. It is he who has suffered the most. His family is ruined, particularly in the case of death and other bodily injury. This is apart from the factors like loss of reputation, humiliation, etc. An honor which is lost or life which is snuffed out cannot be recompensated, but then monetary compensation will at least provide some solace. So, before coming to discussion to this case law, may I take you back to the Indian legal system, which we have inherited from the British. Now, the laws which are enacted, which were enacted, we are mostly still following to those laws. The Indian Penal Code, the Evidence Act are all of British origin, and we are still continue to operate those under those laws. The Indian legal system is based on primarily those laws. But those laws, although well drafted, they were designed with certain, I should say, they were designed to perform certain objectives. The objective was to help the ruling class to rule over India. So the accused, although it is a maxim that no accused should be assumed to be guilty unless proven so his innocence is presumed and guilt has to be proved. But the procedural law was designed in certain ways which are against the accused. The accused has to go through lengthy processes of trial and has to suffer detention, unlawful custody during the pre-independence era. But after independence, we got ourselves a new constitution, and under the constitution, certain rights were protected, certain fundamental rights are recognized, and even an accused has certain very well defined rights which safeguards him from unlawful prosecution under the constitution as well as the criminal procedure code. But the problem is that while ensuring the rights of the accused under the criminal procedure code, we forgot about the condition of the victim. The Indian laws became too much centric towards the accused. It became accused centric. Now the accused has got certain rights prior to his arrest. The accused has got certain rights during his arrest. The accused has got certain rights during the entire trial procedure. The accused has got certain rights even after the trial is over. He has got right of multiple appeals, and even if the appeals fail, he is convicted, he has got certain rights as convict also. So the entire criminal procedural law was designed in such a manner that the right of accused was very well protected. But in the meantime, we forgot to think about the victim. We left the victim far behind. The criminal law is put into motion on the happening of certain event, which can be classified as offense. The offense is directed towards a victim, as we have discussed in the earlier slide. A victim may be a class of people, this entire society. Suppose a banking fraud take place. When a white collar crime take place, there is no one in front of you who can be directly termed as a quote unquote victim. So the entire system is victim of the banking fraud. So if a riot take place and nobody dies, but certain government buses are set ablaze, certain government properties are destroyed. So seditious speeches are given. So the victim is nation. But in those cases, it is the state which prosecute the culprits. But in case of a private victim, a citizen, it is the responsibility of the state to prosecute the offenders, but it is also the responsibility of state to ensure that the victim is rehabilitated, the victim does not feel victimized during the entire trial process, and the victim who was guaranteed by the state to ensure that his life and property and dignity will be protected by the state does not feel neglected by the state. Because in a civilized society, we have given up our right of self-protection, the right that the natural law recognizes, the right to retaliate under condition that the state will protect us from such offenses which tends to take away my life, my dignity, or my property. So when I have given up my right to protect myself and given up the right of private revenge so that we can live in a civilized society, it is the duty of the state to protect those rights. And if it fails to protect those rights, then it is also the duty of the state to recompensate or to provide rehabilitation to the victim. So now gradually the judicial thinking is shifting from the protection of the rights of the accused to the protection of the rights of the victim too, because the rights of the accused is already well protected, and he has the right, the accused has the right to be represented, the accused has the right to get free legal aid, the accused has the multiple rights of having medical treatment during custody. So his rights are more or less well protected. So now we have shifted gradually to recognize the rights of the victim, who should be at the center of the criminal justice delivery system. So not only his bodily injury should be taken into account. When a victim suffers some kind of injury or loss, not only he or she, he or her entire family also suffers with him. They have to go through certain mental agony. They may suffer loss of earning also. If someone is so much traumatized mentally, then he or she cannot perform in his or her workplace. So it is necessary for us to recognize the trauma faced by the victim also. That is why the Supreme Court in the judgment of Maru Ram reminded us that a victim cannot be a forgotten man. It is he or she who should be regarded as the central focus of the entire criminal justice delivery system. Now, if we go to the next slide, we'll find that there are certain relief which are now recognized either by judicial pronouncements or by statutory amendments incorporated in the Criminal Procedure Code and in the Indian Penal Code, and in certain other statutes which are recently passed, to ensure that the victim does not feel neglected. The law recognizes many kinds of relief for the benefit of the victim. We have got monetary and non-monetary reliefs which are recognized by the law at present, which can help the victim feel that the law also takes care of the victim's well-being, and it helps the victim to rehabilitate it. Now, if we go through the monetary relief, we'll find that the victim's right for compensation for loss or injury is now a very well recognized right. Those who are those who have gone through the provisions of the CRPC, since I believe there are some third year students, so they must have gone through some of the provisions of Criminal Procedure Code. So in the Criminal Procedure Code, we have got section 357 and 357A, where the right of the victim to get compensation is recognized. Now, section 357 of CRPC recognizes the right of the victim to get compensation after the trial is over. So after the trial, if the court is of the opinion that the case is proved and the victim must get certain compensation, then the court can, at the time of pronouncement of judgment, direct the accused or the state to compensate the victim for the loss or injuries suffered by him or her. At the same time, in section 357A of CRPC, the law allows the victim to get compensation or some kind of monetary relief even during the course of trial. So in India, we all know that trials are taking a lot of time. Even there are 4-5 crores of cases pending in all over India. And in the lower trial courts, every court is having 4,000-5,000 criminal cases. So those trials will take 4 years, 5 years, 6 years to culminate. But the victim who who has suffered the loss may not survive for 5-6 years to enjoy the fruit of compensation that may be awarded by the court at the end of the trial. So for his or her benefit, we have got section 357A, which recognizes the right of the victim to get interim relief, some kind of monetary compensation, so that he or she may continue with his or her life with some kind of dignity. Similarly, we have got provisions in the law which recognize the right of the victim to get the cost incurred in conduct of the case. Suppose you are not happy the way the case is being conducted by the state prosecutor. So you can assist the state prosecutor by hiring your own advocate, or you can file in certain cases where the state has refused to register FIR, the police has not registered FIR, and you are forced to file a private complaint case before the court. Now, at the end of the trial, if the charges against the accused person is proved, then the court may award the cost of conducting the case in favor of the complainant, who is the victim of the alleged offense. So the cost of conducting the complaint case can also be awarded by the court. Similarly, under 357A and the study material that I have earlier provided under the West Bengal Victim Compensation Scheme, there is also provision for monetary relief for rehabilitation of the victim. Suppose a victim has suffered so much injury that she or he needs rehabilitation. He or she may have suffered bodily injury, or he or she may have suffered mental trauma which has caused loss of her earning. So in those cases, if someone needs rehabilitation, the authorities can order monetary relief for rehabilitation of the victim. We'll go to that part again in the latter slides. Now there is interim relief also that can cover the cost of medical benefits. If someone is a victim of some major offense, cases of like sexual harassment cases of rape, in those cases, a victim can get interim relief, and the district legal services authority also may pass necessary directions so that the victim also gets free medical benefits. Now, these are the monetary relief, and we'll discuss more about them in the latter part of our discussion. Now, there are certain non-monetary relief or rights which the law, after various amendments of the Criminal Procedure Code and the Evidence Act, allows the victim to take part in the criminal trial. Now, the criminal trial, as we have already talked earlier, is more accused centric. So we tend to forget about the victim. The victim is called by the court to adduce his or her evidence, and nobody knows when the victim will be called to the court. And in most of the subordinate courts in our country, we do not have proper infrastructure to host the witnesses. They have to stand in queue outside of the court. There is no proper sitting place. There is no room for the victim to sit. Then we have got child victims. There, under the POCSO Act, there are certain requirements to protect the identity of the child victim. So if there is no proper sitting arrangement for the child victim to give her evidence before the court, then it becomes very difficult to actually implement the salutary provisions that are enacted in the provisions of various special laws. So a victim even can take part in the trial of a case. Suppose a FIR is registered after happening of a certain incident which can be termed as an offense or a crime. Now, when after investigation, the police files a report saying that no such offense took place or the evidence collected during investigation does not justify submission of charge sheet. So they submit a report before the court stating that there is no material to file charge sheet and the investigation is closed. In those situations, a victim can appear before the court and file a protest petition. Now, a protest petition is generally called Naraji petition. Now, a victim can pray before the court that the investigation is not properly done and the court must interfere and direct the police authorities to further investigate the case under section 173 clause 8 of the Criminal Procedure Code. Now, if the court is satisfied with the submissions of the victim, and the victim can produce before the court certain documents also in support of his or her claim that these points were not considered during the investigation of the case. These documents were not collected by the investigating officer. This person was not examined. His statement was not recorded by the police authorities. So there are various latches or lacuna in the investigation. So this case needs to be further investigated. So on hearing of the protest petition or Naraji petition, if the court is of the opinion that yes, in this case, the investigation was not correctly or properly done and the case merits or deserves to be further investigated, in those cases, even on the petition of the victim, the court can direct the police authorities to file to further investigate and file a new report before the court, and on the basis of a further report the court may proceed with the trial of the case. So the right of the victim or anyone related to the victim, because in the definition of victim that we have discussed in our earlier slides, we have seen that the definition of victim includes his or her legal heirs also or family members. So even suppose a victim of dowry death. So a victim of dowry death is no more alive. So her father or parent or anyone related to her or her legal heir may come before the court and file a petition saying that the case was not properly investigated and needs to be further investigated. So this right of victim to ask for further investigation is now well established, well recognized. Now we come to the next point, that is prayer for cancellation of bail. Under the Indian criminal system, it is the state authorities which prosecute the offender of the crime or the offense. So it is the responsibility of the state or the police authorities to investigate the case and place all materials before the court. But if the court, after considering the materials placed before it, enlarges an accused person on bail, in that situation, as per the existing provisions of law, the state can go into appeal to the next upper court for cancellation of bail. The court, the upper court, on hearing the submissions of the excuse me, on hearing the submissions of the public prosecutors and after considering the materials on record, may cancel the bail of the accused granted by the lower court. But if the state fails to challenge the order of bail before the upper court, in such a scenario, although it is not specifically stated in the Criminal Procedure Code that the victim or the dependents of the victim may challenge the bail order, but on the basis of various judicial pronouncements, the right of the victim to challenge the bail order granting bail to an accused is now well established and well recognized. We'll go to the judicial pronouncements subsequently, but now the victim can go to the upper court and say that no, the lower court has wrongly given bail to the accused and considering the relevant materials on record and the particular facts of the case, his bail should be cancelled. So that legal right is available to the victims under the Indian laws. Now, the next right is to appoint own advocate and file notes of arguments. A victim, if he or she is of the opinion that for better conduct of the case, it is necessary for him or her to appoint a private advocate to represent the victim in the court of law during the trial procedure, he or she can do so. The role of the private advocate engaged by the victim is to assist the public prosecutor or assistant public prosecutor, and after the culmination of trial, at the time of hearing of arguments, the victim can file through his or her learned advocate written notes of argument before the court. And those points which are agitated by the victim or on behalf of the victim will be considered by the court at the time of delivery of judgment. The right of the victim to file the right of the victim to be represented by own advocate is now recognized under section 24 clause 8 of the CRPC, and the right of the victim to file written notes of argument is also recognized under the Criminal Procedure Code section 301 clause 2. Now next point is right to appeal. Suppose after trial an accused is acquitted by the trial court, or an accused is convicted, but the sentence imposed upon the accused is not sufficient according to the victim. Now, prior to the amendments of the CRPC, the right of the appeal was solely in the hands of the state authorities. If the state is not satisfied with the order of acquittal, if the state is not satisfied with the amount of sentence imposed upon the convict after trial, then it can go into appeal before the next upper court. But now, under section 372 of CRPC, the right of appeal is also available to the victim. Now, if the victim is not satisfied with the quantum of sentence, suppose if the victim is of the opinion that in this case the accused should have been imprisonment for lifetime, but the lower court has given only 3 years or 4 years or 5 years of imprisonment to the victim. So the right of appeal is available to her to pray for enhancement of the term of conviction or imprisonment. So earlier the right of appeal was only available in case of acquittal. So you can change the order, you can challenge the order of acquittal as a victim, but the quantum of sentence imposed by the court was not available for challenge. But now you can challenge the order of the trial court both on the quantum of sentence imposed by the trial court and in case the trial court acquits the accused person. So this right is also now well recognized in the Criminal Procedure Code. Now, if we can go to the next slide, we'll see that the right of cancellation of bail that we have discussed in the earlier slide is recognized by judicial pronouncement. It is not specifically stated in the Criminal Procedure Code that the victim can go to the upper court and pray for cancellation of bail. But this Supreme Court in R. Rathinam versus State, through judicial pronouncement, recognized the right of the victim to pray for cancellation of bail in case bail is granted by the lower court. So this is a very significant development of law that took place in our criminal delivery justice system. This judge-made law has recognized the right of the victim to take part in the initial stage of the criminal investigation. So earlier, the role of the victim was only confined during the trial. Or after lodging of FIR, the victim was forgotten, and again he was called during the trial process for giving his or her evidence. So in the intervening period, that is after lodging of FIR and before commencement of trial, the victim had no role to play in the criminal justice delivery system or in the investigation of the case. But now, due to this judicial pronouncement, the victim can appear before the court during the investigation period also and give his through his learned advocate, provide materials before the court for praying for cancellation of bail, that due to this relevant points, the accused should not be granted bail. Now this right was recognized by the Supreme Court in the cited case that you can see in your monitor in your screen. The Supreme Court held that the framing of subsection 2 of section 439 indicates that it is a power conferred on the courts mentioned therein. It was held that there was nothing to indicate that the said power can be exercised only if the state or investigation agency or a public prosecutor moves by a petition. It was held that the state power so vested in the High Court can be invoked either by the state or by any aggrieved party. Now, this is the most vital part of the judgment. Aggrieved party. So, any aggrieved party who has suffered injury, who has suffered harm, or who is dependent upon some person who has suffered harm, who is related to some person who has suffered harm or injury, can move before the High Court praying for cancellation of bail. Now, section 439 of CRPC is the section in which bail is granted to the accused, and section 439 clause 2 is the section under which upper court is given the power of cancellation of bail. Now, generally the trial court, that is the court of magistrate or the court of chief judicial magistrate, additional chief judicial magistrate, they give bail to the accused persons under the provisions of section 437 of CRPC. 438 of CRPC is the right of pre-arrest bail granted to the accused person for protecting him from arrest in cases where his arrest is not required. That is more commonly known as anticipatory bail. Now, when section 437 bail is allowed, then the state may go into appeal for cancellation of bail under section 439(2) of CRPC, or the victim or family members of the victim can also go for appeal under section 439 of CRPC clause 2 for cancellation of bail of the accused, citing the judgment of the Honorable Supreme Court delivered in R. Rathinam versus State. So this judgment introduced a very major change in the Indian criminal justice system as far as it relates to the right of the victim to take part in the criminal trial, criminal proceedings before the commencement of trial during the investigation stage of the crime. Now let us go to the next slide, where we'll find that the compensation scheme that is designed for the injury and loss suffered by the victim. Now, I have shared the notification with the panelists last week for circulation among the students. I am only taking you through the major provisions of this scheme. Now, under the West Bengal Victim Compensation Scheme 2017, certain monetary relief is given to the victims of the offenses. Now, if we go through the definition clauses of the, we find that in definition, the definition of victim is also incorporated in section 2 clause I, where victim is defined to be a person who has suffered loss or injury as a result of crime and require rehabilitation. So someone who may have suffered loss or injury and require rehabilitation is termed as victim as per West Bengal and the definition of victim given in the West Bengal Victim Compensation Scheme. But to make up for that, we have the definition of dependent in the Victim Compensation Scheme. So when we go through the West Bengal Victim Compensation Scheme, the definition of victim should be read along with the definition of dependent to get a total idea of the beneficial provisions of this scheme. So the definition of dependent is a person who fully depends on the earnings of the victim. So someone, suppose the parents of child, earning member of the family. So the parents are dependent, the wife is dependent, the minor children are dependent upon the victim. If the loss of life of a earning member of a family take place, then the dependents can claim for victim compensation under the provisions of this scheme. Uh, Let us now pause for a moment and analyze the definition of victim and dependent as provided in this scheme. Uh, you may say that the dependent definition of dependent, as we can see in this scheme, is very narrow. So someone may be emotionally dependent upon someone. I am not dependent upon the earning of my wife, but I am dependent upon her emotionally. So that definition, a friend is dependent, emotionally attached with someone very closely emotionally. So he or she may not be dependent upon the earnings of the victim, but dependent does not mean only monetarily dependent. So the definition provided in CRPC as well as the definition of victim provided in the West Bengal Victim Compensation Scheme is somewhat narrow, but we must keep in mind that victim compensation is designed for compensation. The Honorable Supreme Court and in the various judgments of the High Court, the right of the aggrieved party is recognized to agitate before the courts to point out before cases, but those legal rights are available to all the aggrieved party. But when the monetary relief is, where monetary relief is concerned, we have to go by the narrow definition. So in the earlier slides, we have discussed two types of rights available for the victim, that is monetary rights and non-monetary rights. In case of monetary rights, we have to go by and guided by the narrow definition of victim, because the state cannot afford to give away monetary compensation to everyone who is somewhat close to the victim. You may be close to your friend. You may go to the court saying that in this case the investigation was not properly done. So those rights are non-monetary rights. They may be invoked by any party related to the victim, and that party may be regarded as aggrieved party. But in case of monetary relief, you have to go by the narrow definition of victim, which is provided under the suffered loss, or he or she may be dependent upon the victim for his or her earning. So monetary rights are available only to close relatives, dependents, but non-monetary rights are available to any aggrieved party. That distinction should be kept in mind while discussing the rights of the victim. So what is an offense? Offense is defined in clause E, subclause E of section 2. Offense means any of the offenses mentioned in the Indian Penal Code or any other law for the time being in force. So there are many laws apart from the Indian Penal Code. There are many minor acts like the Protection of Children from Sexual Offences Act. Under those acts, like the Juvenile Justice Act. So there are also some special acts which recognizes the right of the victim to get compensation. So the rights of the victim, if he or she is a child victim, is very now well recognized under the various provisions of the Juvenile Justice Act. Now, since we are not discussing about the child rights today, we'll be not going into those provisions because child rights is such a vast topic that it will merit a discussion of more than 1 or 2 hours. That is a separate topic of discussion. Similarly, victims of sexual offenses, their rights are also protected. And there are special laws for providing compensation to them. But today we are talking about victim in general, which includes every kind of victim, either child victim or victim of sexual offenses or victim of any kind of offenses, which can be included in the definition of section 2E offense of the West Bengal Victim Compensation Scheme. So let us go to the next slide now. In the next slide, we'll see who is eligible for getting compensation under the West Bengal Victim Compensation Scheme, where the offender is not traced. So in certain cases, a case is registered, but the accused is not known, but someone has suffered some kind of injury. Because in the earlier provisions of law, the court under section 357 of CRPC could award compensation at the end of trial, and trial will only take place if the accused person is known. And if the accused person is unknown, no trial will take place, and the court could not award compensation to the victim to be recovered from the accused person, who is by that time declared to be convict. Now, convict can be directed to pay compensation to the victim by the court. But if the accused is not known, no trial will take place and no conviction will take place. In such a situation, if a victim has suffered some kind of loss or injury or harm, then even if the accused is not identified and no trial take place, the victim or his and her dependents may make an application to the state or district legal services authority for award of compensation. So after coming into effect of this scheme, even if an unknown FIR is registered for, suppose, a murder case, a body is found, a death has taken place, an FIR has been registered, but it is not known who is the accused. The family members of the deceased victim can apply before the State Legal Services Authority or the District Legal Services Authority for claiming compensation under this scheme, even though the accused is not known and no trial is going to take place in near future. But there is a proviso, that the proviso is if he or she has not been compensated for the loss of injury under any other scheme of the central or state government, insurance company or any other institution. So if a victim or his family members gets compensation under any other scheme of the government, or if they get insurance money, in that case, this scheme of victim compensation cannot be applied. Similarly, the loss or injury sustained by the victim has caused substantial loss of income to his or family, making it difficult to meet their both ends without any compensation. These two requirements are to be fulfilled. First is that you must not have received compensation from any other government agency or from the insurance company, and secondly, you have to establish that the loss caused to the victim has reduced the earning capacity of the victim, and the family members or the dependents of the victim cannot survive or that is the word they have used is difficult for them to meet their both ends without compensation. So some kind of compensation is required for them to live their life is with dignity. So someone, a earning member, if the victim was the earning member and the death of the victim puts his family in jeopardy and he is not insured, he belongs to the lower strata of the society. They cannot afford to buy insurance policies, they cannot afford to pay premiums of insurance policies. So a loss of life is caused. In such a situation, the dependent family members can come to the court, can appear before the district legal service authority. Now every district in West Bengal, we have got independently functioning district legal services authority with full-time secretary, uh, and a lot of paralegal volunteers are also working there to assist the victim. They guide the victims who are mostly illiterates, coming from the very marginalized background of the society. They guide the victims and their family members through the legal processes, through the process of application to obtain the benefits of this scheme. Now let us go to the next slide where we'll find that how much compensation can be awarded by the authority to the victim or their dependents. Now a victim of acid attack, the minimum compensation provided under the scheme is up to is from 3 lakh. Now this compensation is mostly interim in nature. We must keep in mind that in case a trial take place and after the end of the trial, the court is of the opinion that in this particular case, the loss of earning cost to the victim should be compensated by the authorities. And if the court comes to a finding that this case justifies payment of compensation, say 10 lakh, the court can order, the court can recommend the district legal services authority to make payment of compensation to the tune of 10 lakh to the victim or his or her family members. Now, prior to the trial, the family member has already been paid 3 lakhs as an interim relief. That is the minimum. So 3 lakh has already been paid. So after trial, the court may recommend 10 lakh, for example. So the district legal service authority will, after getting that order of the court recommending payment of 10 and 3 lakh was already paid by the authorities as interim relief prior to commencement of trial. So 7 lakh can further be given in favor of the victim on the recommendation of the court after the trial is over. So this chart, that is the schedule annexed with the victim West Bengal victim compensation scheme, mentions the amount which the authorities are entitled to award uh, during pendency of the trial proceedings, and this minimum amount has to be given to the victim. Similarly, in case of a rape survivor, the victim or his family, her family members may be awarded 3 lakh rupees of minimum compensation. There are various other compensations as we can see in our screen. In case of death, the amount fixed is 2 lakh, that is the minimum. After trial, the court may enhance the amount. There is a loss of fertility, there is loss of cases of disability. Suppose someone lost his hand, limb, leg, then those cases are also covered. So these are the situations in which the district legal service authority or the state legal service authority can award compensation after causing some kind of inquiry during the interim period. That is, even if the trial is not over, the trial may take place 4 year, 5 year or 6 year, but for the temporary relief of the victim and his or her family members, this much minimum amount of compensation can be awarded to the victim. And as a student of law or would-be practitioners, it is our duty to know about these schemes, because when a victim comes to the court or to the advocate, we must tell her that there are certain beneficial provisions that are enacted for their right, and the government has awarded a huge corpus of fund, set aside a huge corpus of fund for awarding compensation to the victims. But if we don't know about the provisions, then how can we assist the victim in getting relief? Because as a student of law, it is our duty to ensure that we live in a equitable world where we get justice, we get fairness, and nobody must feel deprived or left out. So when a victim of crime comes to you as an advocate, before giving him or her legal advice, you can also advise him or her on a right to get temporary relief as per law from the authorities also. So this amount, if you can provide a poor person, a needy person, 2 lakh or 3 lakh of rupees, it will help him or her hugely. So this provision is there, beneficial provision is there. We must make use of these provisions. We must raise awareness level among ourselves as well as the academic world. They can use their platform, their classrooms can be used for raising awareness. Legal aid camps may be organized in remote places, so that the benefits of the provisions of law can reach to maximum number of people. Now, if we go to the next provision, we'll find that in case of a child victim, the age of the victim, if it is found to be less than 14 years, the compensation, that is the minimum compensation, shall be increased by 50% of the amount specified above. So if someone, if a victim is getting 2 lakh rupees, and if the victim is a child victim below 14 years, the amount will be raised by 50% in addition to the minimum amount fixed in the schedule. So these are the various provisions that we have discussed today in the presentation. Now let us go to the next slide. This is for the further reading of the students. If they are interested, they can go through the report of the Justice Malimat Committee. It was on the basis of this report by the Honorable Justice Malimat that various amendments were introduced in the Indian Penal Code, in the Criminal Procedure Code, which recognize the rights of the victim to take part in the trial proceedings, in the post-trial proceedings, for coming to the appeal court for cancellation of bail, for coming to the appeal court for challenging the order of acquittal. So all these statutory provisions recognizing the right of the victim was justified in the report of the Justice Malimat Committee. Similar recommendations were made in the 154th report of the Law Commission of India. So if we go through the provisions, if we go through the various suggestions made in the report of the Law Commission of India, we'll find that the right of the victim was well recognized. Many recommendations were made in this report, so that statutory recognition is given to the right of the victim. Because judicial pronouncement, judgment laws suffers from one issue, that is lack of uniformity. Because one high court is deciding something, the other high court is deciding some other thing. So unless statutory provisions are provided, the laws are not uniformly applied. So we are bound by law to follow the law declared by this apex court. But even in some cases, if we are not aware about the judicial pronouncements, if we are not aware about the judgments passed by the various high courts and the various judgments of the various Honorable Supreme Court, then it becomes difficult for the trial court to apply the law. and it is not possible to know all the judgments. So statutory provisions should be amended so that they can guide the trial courts in discharge of their judicial function. So the Law Commission of India in its 154th report recognized the need of amendment of the procedural laws to incorporate the various suggestions for protection of the victim in the statutory provisions of the Criminal Procedure Code, and subsequently the Criminal Procedure Code was amended by the various amendment acts, and slowly and steadily we are gradually recognizing the right of the victim to be central to the trial procedure of a criminal case. Similarly, the right of the victim is very well recognized in the basic principles of justice for victims of crime and abuse of power adopted by the United Nations General Assembly 1985. On the basis of this resolution, the Honorable Supreme Court has recognized the right of the victim to take part in the trial proceedings, to challenge the order of order of acquittal or the order of sentence, imposing lesser amount of sentence upon the convict. So the Supreme Court has drawn from the principles which are enumerated in the General Assembly resolution in the basic principles of justice for victims of crime and abuse of power. So those international principles are now also incorporated more or less under the Indian criminal justice delivery system. Similarly, in the Ramphal versus state, this case was decided by the Honorable Delhi High Court. Now, this is a very interesting case. Generally, in the criminal law, we do not allow a stranger to take part in the trial proceeding. A victim is allowed by the various provisions that we have already discussed. But in the case of Ramphal versus state, it was decided that even someone who is not directly related to the victim, anybody who is aggrieved, somewhat aggrieved, he or she may also come before the court, and it is the duty of the court to ensure that the trial take place properly, investigation take place properly, and if it is necessary, the courts may even cancel bail even on the basis of application of someone who is not directly the victim or directly related to the victim, but can be defined as aggrieved party. So this is a very important judgment when we consider the rights of the victim under the Indian criminal justice delivery system. So that with that we comes to the end of our presentation. I'll be happy to answer if there is any question within my limited knowledge.
Yes, sir. So there are quite a few questions, and so with your permission, I would like to begin.
Yes.
Yes, sir. The first question is, does it contemplate differential treatment of victims of specified crimes on the basis of time of occurrence of such crime? For example, if a crime happens in 2008, can the victim claim relief under 2017 scheme or section 357A?
Now, thank you for the question. This is a very interesting question. So the prior to amendment of 2009, the right of the victim was not so much recognized. After the amendment, the right of the victim to take part in the criminal proceeding is well recognized. So I have gone through a judgment. I cannot recollect the citation exactly now, because if we allow these already pronounced judgments to be disturbed again, then the cases will go on and the whole system will collapse. Because suppose a judgment of a crime 2009, if that is again allowed to be re-agitated by the victim or the dependents of the victim, then it may cause jeopardy to the rights of the accused also, because on the in criminal law we have this we have to follow this well established principle that retrospective effect in criminal law should be avoided. So an accused whose case has already been decided prior to 2009, or the offense which take place prior to 2009, he has got certain protection in law during that point of time. So if that accused is against called upon by the court to again protect against defend himself, then I believe it will not be compatible to the existing principles of criminal law. But there is a very interesting judgment in on that point that I'll try to get. And if I get that judgment, I have read that judgment very recently. If I get that judgment, I will surely be sharing that judgment with you. And the law is very clearly defined in that judgment, that what will happen in case of an offense which has been registered prior to 2009, and what will happen in cases which are registered after 2009.
Thank you, sir. We move on to the second question, which is which is from Riddhi Jain. So she asks, Clause 2WA of the CRPC defines victim where the accused has been charged. However, in the 2017 scheme, eligibility to the victim is only when the accused has not been identified and trial not commenced. Section 357A of CRPC being the parent legislation to this 2017 scheme, how is such a contraction dealt with?
Yes, thank you. Very interesting observation, very pertinent observation. But as we have already discussed, CRPC, the definition of CRPC is quite wide. But in case of the victim compensation scheme, the victim compensation is only designed for giving monetary relief to the victim or his or her defendants. But in the CRPC, the definition is made wide because there are, apart from the monetary relief, there are many other rights given to the victim in the procedural law. The victim or his or her dependents can appear before the court and engage private advocate. The victim or his or her dependents can appear before the court of law and submit written notes of argument. A victim may appear before the court, and during the bail hearing stage of CRPC is quite wide to the definition provided in the victim compensation scheme. The purpose of those two definitions are quite different. So that is why the definition of victim compensation scheme should be understood in the sense that it is only the victim or her dependent or his dependent who has suffered loss of income and is in need of rehabilitation. So there is a requirement that it is someone who is in need of rehabilitation. The word used is and. So both the clauses has to be satisfied. So you have suffered injury and you require rehabilitation. Then only you can be termed as victim under the West Bengal Victim Compensation Scheme. But when we go to the definition of CRPC, of the victim provided in CRPC, there is no requirement of requiring rehabilitation. You have suffered an injury, then you have the right to come before the court and take part in the criminal proceedings. So this distinction is made, I should say the distinctions are made with certain objectives. To fulfill those objectives, the distinctions, the definitions are different.
Thank you, sir. So we have a third question from one of our panelists, Jhalak Agarwal. She asks, so the Indian criminal justice system is overly optimized, following principles of reformative punishment, which weighs negatively on the victims more often than not. So do you think there is a need for a more deterrent and retributive approach while dealing with convicts in India?
See, during the starting of my discussion, we have briefly touched upon the laws that we have inherited. Now, when we inherited the laws, the the objective of the law was to keep the citizens or the subjects under control, and the punishment was the punishment. The various theories of punishment are there, but purpose during those period was more or less retributive in sense, because we were the colony of the imperialist. So the existing authorities, they wanted to enforce their laws upon us. So the purpose of the laws was retribution in nature. But gradually after independence, the rights of the accused was protected. It was necessary to protect the rights of the accused, because if an accused is wrongly prosecuted, then also the democratic rights, that are fundamental rights that are given to us in the constitution, will become meaningless if the police arrests someone without any proper investigation or without any justification, and puts someone inside the bar, behind the bar. Then all the rights that we have recognized in the constitution will become meaningless. But the rights of the victim obviously got neglected, and the rights of the accused were well recognized by various judicial pronouncements, by various amendments in the criminal procedure code, in the Indian penal code. uh, and that is why gradually a need has been felt to recognize the rights of the victim also. But ultimately, we must keep in mind that a man should be punished for what he has done, nothing more, for what he has done only. He should not be punished for something more. The amount of sentence should be equitable. That is what I mean to say, that if you do something wrong, you should be punished for that only. You should not be punished for something more that you have not done. So the victim can take part in the proceedings now, and if the victim can satisfy the court that in this case the proper punishment should be 10 years, but if the court has given 5 years of imprisonment, then the victim can go into appeal and satisfy the upper court that the lower court has failed in discharge of its duty, and it has imposed less amount of punishment upon the convict. The convict should have been imprisoned for 10 years, but not 5 years. And if the upper court, the high court or the Supreme Court, after considering all the relevant materials on record, the evidences, the conduct of the accused, and the circumstantial evidences, and his chances of reform, because ultimately the purpose of punishment should not be retributive, because we are not living in a pre-independence era anymore. We are an independent nation, and it is the purpose of the state, and it is the duty of the state to reform the citizens. So if an accused is of my very young age, say 20 or 21, and if there is a scope of his reform, then he should not be put behind bars for the rest of his life. If his conduct is found to be proper, and if there is a scope of his improvement, his reformation, then the court must also consider the rights of the victim. So the courts are called upon to balance the rights of the victim as well as the rights of the accused. The door of reformation should not be shut away, and if we enact too much strict laws, then what will happen is that there are cases of malicious prosecution also, false prosecution also. Even the accused can come before the court and file cases against the maker of the FIR for falsely lodging an FIR. So the court has to remain alive to these ground realities, because false cases are also a reality. Victims, sometimes they are not actually victim, but due to societal pressures and other issues to take revenge, to take to settle civil disputes, they tend to file false criminal cases also. But if the law is too much strict, then in those cases also, an accused may be wrongly prosecuted, an accused may be wrongly convicted, and in that case, if we do not consider his chances of reformation, then we will be failing our duty to do justice.
Thank you, sir. So we have one more question. So this is from Devupriya Chottoraj. She is from semester 2, and she asks that in the first slide you had mentioned that law has provisions for getting legal aid to the accused to defend himself. Therefore, for a person who has voluntarily surrendered himself to the court of law, is the same provision applied?
See, the right of legal aid is available to any accused. If he is brought under arrest before the court and if he is undefended, he is not represented by anyone, then also the right of legal aid is applicable. And if the accused has surrendered before the court and he is taken into judicial custody, and he may apply, submit before the court that I am indigent, I am poor, and I have no financial capacity to represent myself, then also the court can appoint any advocate who is in the legal aid panel maintained by the District Legal Services Authority for appointing him to represent the accused. Generally, what we do is that we make an observation in the judicial order sheet that this accused is not defended, not represented by any learned advocate. So an advocate from the legal aid panel may be appointed the court to the District Legal Service Authority with a request to appoint any learned advocate from the legal aid panel for representing the accused before the court on the next date of hearing. So even an accused is brought before the court under arrest, or an accused who has surrendered before the court, both of them are entitled to get free legal aid if certain conditions which are provided in the Legal Services Authority Act are fulfilled.
Thank you, sir. So it's a request. Actually, your video is frozen. If you could restart your camera, it would be good.
Now,
So your video is not visible.
the video is not okay.
No, sir.
No, I think it is internet connectivity issue, and mhm. I hope I am audible at least.
Yes, sir. You're clearly audible.
Yes.
No problem,
And,
sir.
video is frozen on my end also.
No problem, sir. With your permission, sir, we would like to proceed.
Yes, proceed.
Thank you, sir. I would now like to begin with the vote of thanks. To begin with, thank you so much, Mr. Vikramjit Sen. So thank you so much for coming here and joining us and taking out your precious time and providing us with detailed information, so which helped us to better understand the situations of the victims, because all of us, we read in the news like what has happened to the victims and what is going on, but nobody's interested to know beyond that, like what the victims can do, or what is the avenue available to the victims. So thank you for that. And I would also like to thank our Vice Chancellor, Reverend Father Felix Raj, our Pro Vice Chancellor, Reverend Father Sebastian Raj, and our Registrar, Mr. Ashish Mitro, for their constant support. I would also take this opportunity to thank the Dean of Xavier Law School, Dr. Pratyusha Das, and the convener of XSLAJ, Dr. Animesh Das, for their constant guidance and support. I would also like to acknowledge and thank the IT office without whom this event would not have been possible. And I would also like to thank the team of Colawquia for their constant support and their work, which made this event possible. And last but not the least, I would like to thank the audience for their participation and their presence in this webinar. And lastly, I would like to invite Dr. Animesh Das, the convener of the XSLAJ, for the closing address.
Thank you, Ronald. It has been really a great pleasure hearing one of the most iconic senior we have in our college. Most of us, we idolized him, and today I could meet him after so many years, almost after 10 years, maybe more than that. And it was really a very engaging talk, something that most of the students can connect themselves to because they are learning CRPC. They have already studied ITC, and probably some of them have already studied evidence as well. So, and from the point of view of other jurisprudential aspects like how rights can be defined and rights can be understood, this has really been something which has definitely helped our student in various aspects. Thank you again, Vikram Da. I would call him Vikram Da because that is what we have been calling him for so many years. I couldn't change it. Thank you very much, Vikram Da, for joining us. And we hope that once everything starts getting completely offline, we'll probably be in a situation to call you sometime. If you have some time for us as well, that you can manage some time for an offline lecture as well. Thank you very much. Thank you all the team for conducting this, and thanks to all the participants. Thank you very much.
Thank you to Dr. Animesh. And as I have told, I have the pleasure of knowing him for more than a decade. Thank you to the Xavier Society of Law and Justice for having me. To all the panelists, thank you for bearing with me. And all the participants, I hope, see, this is my first, I think, online presentation, and I am not used to taking classes in online, but I hope to meet you all of you in person someday when things are better in future. And I quite enjoy talking with students, so hope I'll be meeting you. And my sincere gratitude and thanks to the members, faculty members of the law school, to the Honorable Vice Chancellor of the St. Xavier's University, the IT team, which have been assisting me for the last 2 days, and all the organizing members of the panel discussion. Thank you so much.
Thank you so much, sir. And sir, with your permission, sir, we would like to give the permission for dispersal, sir, for the students for the next class.
Okay, sir. Thank you.
Thank you, sir. Thank you, everyone. With this, we come to the end of the 4th episode of Colawquia. Thank you, everyone.
এই অম্বিকা আছো না? বাড়ি যাবে? তাহলে চার্জগুলো করবো না? তাহলে কি করবো?